My name is Allison Smith, and I'm with the National Laboratory of the Rockies, formerly the National Renewable Energy Lab, or NREL. We are NLR now, and we're so grateful to have you here with us today. Go ahead and share. We'd like to welcome you to our fourth webinar in our series, State and Tribal Collaboration on Energy, Government to Government Best Practices. We have some wonderful speakers today that we're very honored to have with us to share from their experiences on this topic. So we'll start with a quick overview of NLR, the National Lab, give you a little background on who we are, how this project came to be. And then we'll hear from Commissioner Darcie Houck with the California Public Utilities Commission. We'll hear from Katie Sieben, the chair of the Minnesota Public Utilities Commission. And then we will hear finally from Pilar Thomas, a tribal energy consultant, who will share an overview of government to government best practices. We will have time for Q&A, and we'll also share a couple of resources as well. I want to introduce you to our team. As I said, I'm Allison Smith. I'm a project manager. I'm led by Carlin Corey, our principal on this project, as well as Emma Burkow and Milana Pakes, who are researchers who have contributed hugely to the work that we've done so far. This project has been funded by the Department of Energy's Office of Policy in coordination with DOE's Office of Indian Energy, and we've really enjoyed having their support on this project. I want to take a second to just say that we express our gratitude and acknowledge that the land our main campus is on in Golden, Colorado, is the traditional and ancestral homes of the Arapaho, Cheyenne, and Ute peoples. We recognize and pay respect to the indigenous peoples from our past, present, and future, and we are grateful to those who have been and continue to be stewards of our land. Just an overview of the lab itself. We are one of 17 federal research laboratories under the Department of Energy. Our focus is on energy systems transitions, transportations and fuels, buildings and industry. And we have successfully collaborated with industry, academia, government, as well as local entities such as communities and tribes. We have 4 campuses. If you ever make it out to Golden, Colorado, I highly recommend doing the tour at the National Lab campus. It is absolutely beautiful. As I mentioned, we've partnered with over 3,000 communities, tribes, jurisdictions, utilities, and businesses in lots of different forms. We've provided technical assistance for project implementation. We've helped support research projects. We provided strategic energy planning, as well as capacity building, workforce development, and more. We are one of the main labs that do outreach to communities and tribes and are happy to do this work across the country and in all of the U.S. territories. This particular project, as I mentioned, was funded by the Office of Policy, and our key goals of the project were to identify and answer questions that states had about tribes, about tribal energy support, and tribal energy issues. Office of Policy was asked by several state energy offices how they could better collaborate with tribes in their state, and so this project came to be in order that we could provide that support to states interested in that. So we want to identify ways for state governments and tribes to successfully collaborate on tribal self-determined energy goals, which often align with the state's goals. Our deliverables for this project are to publish 6 fact sheets, which we will find on the website for this project, and we'll share that at the end with our additional resources. We held 2 in-person trainings, one in Colorado and one in DC. The materials from those workshops can be found on our project website, and we'll be holding 5 webinars. This is our 4th. We are happy to have our presenters here today, and at the end, we will also talk a little bit about our final webinar that will be held on March 18th. So grateful that all of you have joined us today for the webinar. I will now turn it over to Commissioner Houck to present on the work that's being done in California by the Public Utilities Commission.
Thank you. I really appreciate being part of this program and being able to present to you on what we're doing in California at the California Public Utilities Commission regarding our state tribal relations, our tribal policy, and some of the current work that we've been doing. Please go to the next slide. So just as an overview about the California Public Utilities Commission, we regulate investor-owned utilities, protect consumers, safeguard the environment, ensure California's access to safe and reliable utility infrastructure and services. We regulate the following industries. We regulate energy, investor-owned electricity and natural gas companies, telecommunications. We manage broadband and communications providers, and manage grant programs as well as service quality and other areas regarding telecommunications. We also regulate rail and passenger carrier safety under transportation, and the investor-owned water companies, which are about 16% of the connections in California. 16% may not sound like a lot, but it's actually a fairly significant amount of water providers. Next slide, please. So the roles of the commission in regards to energy, because I know that's our focus today, is energy. So primary responsibilities include rate setting for investor-owned utilities, which includes review of cost of operating and maintaining the utility system, allocating cost across customer classes. This is primarily done through the general rate cases and then other rate setting proceedings, which typically are applications filed by the investor-owned utilities to request authorization to spend money and recoup that money from ratepayers. We also are responsible for energy infrastructure planning, and we coordinate infrastructure and resource planning with the California Energy Commission, which is the equivalent of California State Energy Agency, and the California Independent System Operator, which is primarily responsible for managing our transmission system. Our responsibilities include both transmission and distribution systems. And our oversight, we oversee and administer programs for customers, including our income qualified assistance programs, such as the California Alternative Rates for Energy, Energy Savings Assistance, and Family Electric Rate Assistance. Our energy efficiency programs, building decarbonization, our microgrid incentive program, and our self-generation incentive program, which provide funding to put in either microgrids or it's basically behind the, and SGIP is behind the meter infrastructure. Next slide, please. So our tribal consultation policy, the commission was a little bit later than a lot of the agencies in California. The first formal tribal consultation policy for the Public Utilities Commission was adopted in 2018. This is consistent with Executive Order B-1011, which was an executive order issued by former Governor Brown that required state agencies to have consultation policies. Our TCP, or tribal consultation policy, goals include respect for tribal sovereignty and protecting tribal cultural resources, consider tribal interests and facilitate tribal government participation in our proceedings and programs, and encourage investments by tribal governments in renewables, storage, efficiency, and low carbon transportation. Our tribal advisor at the California Public Utilities Commission is a governor appointee position, and they're responsible for coordinating outreach, communication, education, and activities affiliated with tribal interests. So they have responsibilities both internally and externally to the commission. They need to basically advise our staff on the best way to engage with tribes, ensure they understand proper protocols, and that they have the information they need when engaging with tribes. And then they are also engaging externally and are intended to be the first point of contact for tribal representatives if they're seeking information, have concerns, or want to engage with the commission so that they can point them to the right individuals and divisions. And then it sets out protocols for consultations with tribes. Next slide. So right now we have a rulemaking where we're proposing changes to the existing consultation policy, and the modifications include, making it clear that we want to engage in early, often, and meaningful consultation. Early meaning before commission actions and decisions have been made, and as early in the decision-making process as possible. I think, a lot of us all too often have seen that issues don't come up till after we've made a decision and it's implemented. So we want to make sure that we're doing our best to provide information early to tribes so they know what policies we're considering and can weigh in at the soonest possible time. Often means the commission will strive to build relationships with tribes on an ongoing basis before consultation is needed. And one of the things we're looking to propose is quarterly tribal information meetings where our commission staff will be meeting with tribal representatives from any of the tribes in California that want additional information, but to set up regular and ongoing meetings. Meaningful requires the commission to understand, respect, and consider tribal feedback. The commission intends to contact tribes and may initiate consultation when it determines that its actions may have implications on tribal cultural resources, ancestral lands, sacred sites and landscapes, access and use of ancestral lands, ancestral land return, natural resources, economic development, and other areas that the commission regulates that we know will impact tribes. The commission also intends to facilitate tribal government participation in programs and proceedings. So where needed, the commission will ensure that tribes have the information they need for grants, subsidies, incentives, or formal proceedings. And if the tribe believes that the tribal consultation policy has not been filed, they can provide a written letter to the commission's executive director that will result in a response and appropriate actions within 30 days from receipt of the letter. Next slide, please. So additional revisions that we're looking at include coordinated and consistent approaches to tribal consultation across our divisions. And what that means is that we'll be looking to delegate tribal liaisons in each of our major divisions so that there'll be a point of contact for our tribal advisor to go to when they need information related to that area, and that those individuals will be responsible for working with the tribal advisor, engaging and assisting with tribes, and ensuring that they're able to get the right information. The Public Advisor's Office at the Commission, which is different than the Tribal Advisor's Office, can also provide support for the Tribal Advisor. Our Public Advisor's Office basically is an office that's there to advise the public on how to participate in our proceedings. They're very familiar and understand all of our rules of practice and procedure, how we make decisions, and what divisions we have within the commission. So they will also be able to provide support, again, to our tribal advisor and to tribal representatives in understanding how to participate in our commission proceedings. So we also are going to be listing out in our policy informal and formal consultation. And informal consultation is where tribal representatives are encouraged to reach out to our Office of the Tribal Advisor, who is supported by the tribal liaisons and the Public Advisor's Office, if issues come up or they need information, so that hopefully issues can be resolved on the ground very quickly. To the extent informal consultation doesn't address issues, we have a formal consultation government to government process between official representatives of the tribe and the commission, and this is initiated via a formal request to the tribal advisor and will involve our executive director or the relevant commissioners with the tribal representatives as needed. Next slide, please. I also want to talk about the commission has, and I think it was the first in the nation, a tribal land transfer policy. And this was adopted in December of 2019. And the goals of the policy are to respect tribal sovereignty, protect tribal cultural resources, consider tribal interests, and facilitate the return of lands within a tribe's ancestral territory, facilitate notice and tribal participation in matters involving real property transferred under Public Utilities Code Section 851. The tribal land transfer policy came out of, there was a prior proceeding where one of our utilities was divesting itself of a significant amount of land, and we found that tribes who that land had historically belonged to and had been taken from in various ways did not have an adequate opportunity to really address return of that land. So there was a number of meetings and consultations, and we developed this policy. And prior to investor-owned utility, this policy requires that prior to divesting real property, investor-owned utilities must first provide notice to tribes and offer applicable tribes the right to take or purchase the property. So there's basically a first right to the tribe to be able to either purchase or in some cases donate the utility to donate the property. And this applies to investor-owned utility property whose disposition is subject to approval by the commission. Next slide, please. So the commission proposes revisions based on feedback that we've received from tribes through consultations held from 2022 to 2025, or actually most recently, it should say 2026, because we had a consultation last week with a number of tribes and a workshop where we met with tribes and formal comments that we've received. Some of the modifications to the proposal include extending the notice period to 90 days, during which the tribe must express interest in the transaction, create tribal ancestral territory overlays as reported by tribes on maps of IOU property, introduce quarterly meetings with IOUs and staff regarding compliance with the policy, and create a uniform website for each investor-owned utilities reporting. We've received a lot of comments. We're considering those comments, so it hasn't been determined that these changes will be made. These have been proposed, but we are considering all the comments that we've received. Next slide. I also want to talk a little bit about broadband. I know the focus is energy, but we know that technology and broadband access is important to having access to especially behind the meter resources. And our tribal broadband program includes a technical assistance program where we provide $250,000 a year per tribe that applies and meets the requirements of the program for broadband and related studies, business plans, grant writing, consultants, administrative costs, and other areas that are needed to develop a broadband project. We also have our California Advanced Services Fund, which has broadband infrastructure grants where there's hundreds of millions of dollars have been invested in broadband since 2008. And we're currently considering 2 tribal applications in the range of $25 million each. We have created, at the end of last year, tribal broadband consortia. We have consortia that are throughout the state tied to each county, but we felt it was important to have a consortia that was going to be able to address the specific needs of tribal communities. And so we are currently soliciting applications for tribal consortia, which will be tribal entities or community-based organizations that support tribes in applying for broadband funding. And we're going to be hosting 3 regional workshops throughout the state to get input from tribal representatives on what they want these consortia to look like. There'll be one in Northern California, one in Central, and one in Southern California. We also have a federal funding account where we've invested over $1 billion since 2024 to serve unserved areas. This includes $174 million to 9 tribes for broadband networks. And then we have the BEAD program, which our award was roughly $1.6 billion to serve unserved areas in California. And currently there are 2 potential tribal sub-grantees and 4 projects that may serve tribal areas once we get our final approval from the federal government for our BEAD program. And then last, we've got our California Lifeline program, which provides up to $64.25 a month on tribal land. California provides $30 a month for broadband and voice. Federal government provides $9.25 a month plus a $25 a month additional amount for customers on tribal land. And I know that was a lot of information really fast. I think that was my last slide, but go to the next one. So again, I really appreciate being able to participate and talk about the work we're doing. The one last thing I do want to add is we did find that we were getting a lot of issues raised by tribal representatives on right-of-way issues, whether it was right-of-ways that weren't authorized on tribal land or tribes having difficulty getting right-of-ways to energize housing and get service line extensions. And so what we did was we brought our investor-owned utilities, the Bureau of Indian Affairs, and the state agencies, Caltrans, the California Department of Technology, the PUC, all together in one room to kind of talk about what the things on the ground were that were happening. We had an initial meeting in Sacramento, and then we did another meeting up in Blue Lake, Rancheria, and one down in Rincon in Southern California. And we were really pleased to have Pilar come and speak at that meeting. But it was really helpful. I think it was really positive, and we've heard good feedback. And we met with some of the utilities last week where right-of-way issues were continuing to be discussed. And it seems like there's a long way to go, but there's a lot of progress, and that the workshops have really helped make sure we're connecting the right people together to communicate about what's needed to get those resources to tribal lands. And with that, I will conclude my presentation, and I apologize that I think I took more time.
No problem, Commissioner. Thank you so much for sharing that. That was wonderful to hear about what's been going on in California and the work that you're doing there. I just want to pause and see from my colleagues if we have any questions in the chat or in the Q&A. And if anyone wants to raise their hand, I'm happy to allow you to ask your question live as well. Pause for just a moment. Let our next presenter get set up. All right, we will come back again for questions. We will have more time for that. That was a lot of information, and we appreciate all the work that you're doing in California, Commissioner. Thank you so much. So next, I'm going to turn it over to Chair Katie Sieben with the Minnesota Minnesota Public Utilities Commission. Thank you so much for being here today. We appreciate it, and I'll let you introduce yourself.
Thank you so much, Allison, and thank you to Commissioner Houck. That was a great presentation, and I heard a lot of similar instances of what we're doing in Minnesota that were reflected in Commissioner Houck's presentation. So really appreciate the opportunity to be here and to try to share some of our best practices in Minnesota that are helping us to improve relationships with our state's tribal nations. So by way of background, I was first appointed to the PUC in 2017. That followed 14 years in the legislature, where I represented a suburban area southeast of the Twin Cities in Minnesota. In my time in the legislature, I worked on energy issues and represented a district just north of the Prairie Island Indian Community Reservation, which lies along the Mississippi and Vermilion Rivers in southeastern Minnesota and is home to descendants of the Mdewakanton Band of Eastern Dakota. So, like most regulators who were previously legislators, I knew a little bit about a lot of issues. And for the first 2 years on the commission, I was not the chair. And the most controversial docket that we struggled with as a commission was the siting and permitting of the Enbridge oil pipeline, which is a now constructed 340-mile plus replacement line that runs through Minnesota from North Dakota. The docket, and I'm sure many of you have heard of it, it was really controversial with the public, and there was widespread opposition to the replacement of the oil pipeline by tribal governments and tribal members across the state. But there was also a tribe that hosted the original Line 3 oil pipeline, the Leech Lake Band of Ojibwe, that did not want the replacement line to follow the same path as the old line. And the commission ultimately moved the route of the new oil pipeline, imposed many conditions, and there was controversy around siting the new route, certainly, but I really felt that there was lasting animosity between tribal members and the commission, or there was animosity directed from tribal members to some members of the commission. So when Governor Walz, then Tim Walz, became the governor in 2019, he appointed me as the chair. And now I'm serving my second 6-year term. And as you'll see on the slide, these are my colleagues on the commission. Oh, back one slide again. Still Angie, thanks. Commissioner Tuma was the other commissioner I've served on the commission since that line 3 docket. He's a Republican and is also very interested in improving relations with our 11 federally recognizable tribes in Minnesota. And joining me on the call today is Angie McKinley, our commission's tribal liaison, who does, I should say, like right up front, a wonderful job leading our tribal affairs work. Commissioner Houck, who's pictured, also works closely with Angie, our staff, and the other commissioners on improving our commission's DEI activities. And although I don't put our DEI and tribal activities in the same bucket for various reasons, I mention it because in Minnesota, we're purposefully driving engagement in new ways, looking for community voices and people that have not been traditionally engaged in our utility decision-making to get involved. This hasn't been done to the extent previously, and it's something I'm really proud of our staff and the commission for undertaking. The Minnesota PUC believes firmly that including tribal perspectives and tribal voices in our proceedings and processes enhances our ability to make equitable decisions that are in the interest of all Minnesotans. We're dedicated to building and fostering relationships with tribal leaders that are grounded in mutual respect and cultural humility, and recognize the unique status of our Minnesota tribes. So in the following slides, I'll highlight some of the policies, roles, and resources we've implemented to fulfill our commitment to honoring the government-to-government relationship with tribes and to ensure that our collaboration is effective in achieving positive outcomes. Next slide, please, Angie. In Minnesota, there are 7 Anishinaabe or Chippewa and Ojibwe reservations and 4 Dakota or Sioux communities. A reservation or community is a segment of land that belongs to one or more groups of American Indians. It's land that was retained by American Indian tribes after ceding large portions of original homelands to the United States through treaty agreements. It's not land that was given to American Indians by the federal government. There are hundreds of state and federally recognized American Indian reservations located in 35 states, as you know. These reservations have boundary lines much like a county or a state does. The American Indian reservations were created through treaties, and after 1871, some were created by executive orders of the President of the U.S. or by other agreements. Even though the commission does formal consultations with these 11 tribal nations that share geography with Minnesota, we sometimes hear and welcome engagement from other tribes located in other parts of the country. So the 4 Dakota communities in Minnesota, or that share boundaries with Minnesota, include the Shakopee-Mdewakanton, located south of the Twin Cities, Prairie Island that I mentioned at the beginning, the Lower Sioux located near Redwood Falls, and the Upper Sioux the lands are near the city of Granite Falls. The original Dakota community was established by treaty in 1851, where the treaty set aside a 10-mile wide strip of land on both sides of the Minnesota River as the permanent home of the Dakota. However, in the aftermath of the U.S.-Dakota conflict of 1862, Congress abrogated all treaties made with them, and the Dakota were forced from their homes in the state. The 4 communities were reestablished in their current localities by acts of Congress in 1886. The 4 Dakota communities today represent small segments of the original reservation that were restored to the Dakota by acts of Congress or proclamations of the Secretary of the Interior. The 7 Anishinaabe reservations include Grand Portage, which is located in the far northeast corner of the state, Boyce Fort in the extreme north, in kind of like up in the chimney part of Minnesota. That's on the map there. Red Lake, which is located in northern Minnesota west of Boyce Fort, and White Earth, which is located in northwestern Minnesota. Leech Lake, Fond du Lac, and Fond du Lac is located just north or just west, excuse me, of the city of Duluth. And finally, Mille Lacs is located in the central part of the state, just south and east of Brainerd. So again, all 7 Anishinaabe reservations in Minnesota were originally established by treaty and are considered separate and distinct nations by the United States government. Next slide, please. To understand where the Minnesota PUC stands today, I'm showing you a 20-year evolution of how the state of Minnesota has recognized tribal sovereignty. This timeline shows a steady progression from high-level affirmations to specific codified legal requirements. In 2002, Governor Ventura signed an executive order which formally affirmed the government-to-government relationship between the state and the 11 tribal nations. A year later, Republican Governor Pawlenty maintained this momentum by signing Executive Order 305. And then in 2013, the framework became more operational when Governor Mark Dayton established Executive Order 1310, which moved beyond general affirmation and set specific consultation expectations on cabinet agencies. Then in 2019, when Governor Walz took office, he signed Executive Order 1924, which strengthened consultation requirements for state agencies. But, and this is important to note for us, the PUC in Minnesota is not a cabinet agency. And so the previous governor's efforts to increase tribal engagement didn't extend to our work. And it was following the somewhat difficult docket, line 3. Well, it was very difficult actually, that following line 3 that led us, the commission, to adopt our first tribal engagement and consultation policy, which formalized our state agency's commitment to tribal consultation. The commission, under my direction then as time as chair, but with the support of all of the commission and our staff, we hired a tribal liaison and began mimicking the work of other state agencies. Following the success of this engagement and seeing the impact it was having in our dockets and at the legislature, we worked with legislators and our staff in 2024 to codify our tribal consultation policy into Minnesota Statutes 1065, ensuring our consultation duties are a permanent fixture for the Minnesota PUC's future. Next slide, please, Angie. So this is a picture of one of our previous consultations. And it outlines what is in Statute 1065. So again, this already existed, but a couple of years ago, we got a bill passed and Governor Walz signed it into law that formalized the PUC was a part of Statute 1065. So there are the 3 points there, and that now the Minnesota PUC is a part of. Next slide, please. So a little bit more on the details of our tribal consultation. The policy is built on a commitment to government to government relationships, and we update our policy to keep it fresh every 2 years. But unlike other state agencies, because we're quasi-judicial, and we act like a court, our consultation process is different than other state agencies. Like many of your commissions, we balance our duty to consult with strict rules regarding ex parte communication. So these are some examples of how we put it into practice. Every year, at least one, and usually two commissioners and our staff meet with each of the 11 tribal nations to build trust and to discuss specific utility or telecom issues. We do specific issue consultation. A tribe or the commission can request a formal meeting on a specific docket or a policy change. And again, because of our ex parte requirements, if a consultation is required on a specific docket or item, we have to do that in public per our ex parte requirements. But sometimes we can have discussions that have been very fruitful regarding potential policy changes. This next point I think is important. We try to engage early, either through our staff or through our annual consultations. So we're not waiting to hear about a conflict. If I found, and our staff has certainly been wonderful in making this happen, if we prioritize timely notification, reaching out to tribal leaders and historic preservation offices at the start of the regulatory process, we often are able to flag difficult issues and facilitate a process that can lead to less conflict in our regulatory process later on. Our goal is to ensure that tribal voices are part of our formal record. And this is kind of hard because, as you know, commission processes are formal, are complex, and are not usually a place where, groups outside of utilities traditionally engage. But by doing this outreach, it helps ensure that when we're making a decision, it's informed by the perspectives of the sovereign nations that are impacted by the Commission's decisions. These discussions are valuable opportunities for tribes and commissioners to stay informed and to nurture open and mutually respectful relationships. Next slide, please. Central to our consultation framework is the role of the tribal liaison, and Angie, who's on, is this star player in this. Her position isn't just a point of contact. It's the vital link that ensures the commission meets its legal and ethical duties to Minnesota's 11 tribal nations. The liaison is responsible for implementing our tribal consultation policy, making sure that we're staying up to date on it and, meeting the standards that we've incorporated into our daily work. Angie is the principal point of contact, coordinating both our required annual consultations and any issue-specific meetings that arise throughout the year. She also serves as a key advisor to the commissioners and our executive secretary, and she really helps facilitate cultural understanding and that relationship building and issue-specific decision-making with our staff that are working on specific dockets. Critically for the nations themselves, the liaison acts as a navigator. They manage our notification lists, which are not always that easy to understand, and ensures that tribal governments and historic preservation offices are alerted to relevant dockets and assist tribal staff in effectively participating in commission proceedings without providing legal advice. So the liaison, and Angie in this case, ensures that meaningful consultation is more than just a phrase. It's consistent, proactive, and respectful government-to-government process. Next slide, please. The state recognized the importance of all employees, leaders and staff alike, to build an understanding of American Indian culture, history, laws, and government structure when it established the Tribal State Relations Training Program in 2013. What's unique about this program is that the content and curriculum have been informed and shaped by tribal leaders since its inception. So it's a 2-day in-person program that's led by tribal leaders and covers a wide range of topics, and it includes discussion panels that feature tribal leaders, tribal staff, and Minnesota state government leaders. The trainings are offered throughout the year, are hosted by each tribal nation, and expenses are covered by the state. So not only in our case have our commissioners attended tribal state relations training, but so have our senior staff and many of our state employees. As a result of this program, state employees are given the foundational training that better positions them to effectively interact with tribal governments and citizens, tribal citizens, in representing the state of Minnesota. It's really a critical piece of our state's success in building and fostering healthier relationships with tribes. Next slide, please. In addition to the mechanisms of annual consultation, employee training, and the role of the tribal liaison, the Commission also relies on a wide network of tribal leaders, tribal staff, tribal historic preservation officers, and advocacy groups to participate in our process and share valuable perspectives. We've really tried to build trust with these stakeholders and have seen that that has resulted in better decisions for the Commission. Next slide, please. So this is just an example of a bill that was introduced last week. I think, well, the legislative session began last week here in Minnesota. And the bill, it's only a bill at this point, would exempt tribal reservations from state laws that assign service territories for and exclusive service rights for electric utilities. I've sort of have been following this and have heard discussions about this nationwide, efforts like this surrounding self-determination and sovereignty. So we're not sure yet where it will go in Minnesota or if it will proceed this legislative session, but I just offered it as an example of a piece of legislation that we will certainly track and watch carefully this legislative session. Next slide, please, Angie. So as I discussed over the past several years or many years, we've worked to ensure that tribal voices and cultural preservation are part of our decision making. In Minnesota, we do siting and routing for large energy infrastructure projects. And a really good example of this engagement, I think, is the Big Bend Wind and Red Rock Solar Project. At the time, it was the state's largest hybrid renewable project. And initially, it faced significant opposition from tribal groups due to its proximity to the Jeffers petroglyphs, a 7,000-year-old sacred site that had nationwide tribal historical artifacts and importance. So in 2021, the Commission, following a great tour we had of the petroglyphs with tribal leaders, noted the project that it was not on a good path and commissioners insisted on deeper engagement between the applicant and tribal nations in one of our commission hearings. This created a space where the applicants, the Minnesota Historical Society, and the Lower and Upper Sioux Indian communities eventually reached a settlement. I remember that commission meeting and hearing tribal leaders describe the process as respectful and a sovereign to sovereign government example of good work done by the commission that led to an agreement that everyone could be proud of. We see similar results in other projects. In a really large transmission project that goes from kind of along the Mississippi River in the Mankato area, the final route was specifically modified to avoid tribally sensitive areas. And more recently in the Northland Reliability Project, another transmission project, we facilitated a project where tribes could request the applicant work directly with their TARO, which is their Tribal Employment Rights Office, to ensure the inclusion of a tribal labor force during construction. And this is an important component in best practice that I want to emphasize. When state utility commissioners ask applicants or utilities to engage with tribal governments and hire tribal members where applicable to help build the energy infrastructure we all need, I really consider that a win-win. In 2022, we initiated tribal outreach during a potential rulemaking for a CO2 pipeline. And today we continue that work in other active dockets, like the Magellan Pipeline reroute, which is another oil pipeline that was previously routed through a sacred site. The Pipestone National Monument is a storied landscape. Numerous tribes around the country have oral traditions connecting them to this site, and Euro-Americans have been visiting and writing about it since the 1600s. And archaeologists have found evidence for over 3,000 years of human activity. Today, the Pipestone National Monument is officially affiliated with 23 tribal nations, and Indigenous people from across the country keep ancient quarrying traditions of the Pipestone alive. As part of the Commission's work to approve a newer, less damaging route for this pipeline, we required the Magellan Company to complete cultural, archaeological, and historical resource inventories for 2 route alternatives, one of which was proposed by a tribe. We also ordered the applicant to collaborate with 15 tribal nations and entities, including tribes from out of state. The Commission has yet to make a final routing decision, but either of the 2 route alternatives, I think what will happen will be further away from the Pipestone National Monument than was earlier proposed by the company. So that's my final slide. I'm happy to answer any questions and turn it back to you, Allison.
Thank you so much for that presentation. That was wonderful. Grateful for your participation today and to hear what's happening in Minnesota. I'm going to pause for my colleagues to see if there are any questions in the Q&A. I'm sorry, Pilar?
No. Sorry, I don't have any questions. I was just getting ready.
Okay. All right. We'll start in just a second. Let me just check if there are any questions in the Q&A. And apologies that the chat is disabled, but you can put questions in the Q&A and we'd be happy to answer them. And again, we'll have a little bit of time at the end for that as well.
There's no questions in the Q&A currently, Allison.
All right, thank you, Milana. Great, then I will share my screen and I will turn it over to our next presenter, Pilar Thomas. It has been a pleasure to work with Pilar. She has brought so much expertise to this project and we're grateful for her participation today. So I'll turn it over and let Pilar introduce herself.
Great, thank you, Allison. And first, I apologize that I don't have my video on. 2 reasons. 1, I'm in Mexico, and 2, for some reason, my camera is inverted. So I didn't want to share a picture of the beach. But first of all, thank you, Allison and the team at the National Lab of the Rockies for asking me to present on this important conversation. I think this is the last of our webinars in this project, and I've been very honored to participate with I'm not supposed to call it NROC, am I? Just National Lab of the Rockies. I'm trying not to say NRAL. But I want to thank everybody, and I want to thank the team, and I especially want to thank the commissioners from Minnesota and from California for participating. Great overviews and really in-depth information about what's happening in their particular states. I'm going to walk through a presentation that I gave, as you can see, last month in an in-person workshop, and lots of folks there in Golden, and was asked to present on kind of best practices in this area of state and tribe government to government relationships. So I'm going to maybe take a step back because we heard very in-depth from California and Minnesota public utility commissions on their policies, the background on their policies and their work with tribes. There are a few other things also happening in those two states that I'm going to cover. I'm also going to cover what's happening in New Mexico, which was kind of the leader in states establishing formal state tribal government to government relationships. So let's turn to the next slide. So we're going to maybe do a background, as I said, maybe take a step back, a background on tribal government status and why states like California, Minnesota, New Mexico, and others treat tribes differently. As you heard from the commissioner, it's not quite DEI, it's very different relationship. So what is the legal reason for that? Not just a political reason, but an actual legal reason. Maybe a little bit more of the modern history of government to government relationships between mostly the federal government and tribes, but now, again, more and more states stepping into that relationship. A summary of different types of tribal and state relationships that sometimes form the basis for the current one is between tribes and states vis-a-vis energy. There's a long history of tribal state relationships in other areas, industry sectors, and other areas of the law. I'm going to do a short overview of kind of what the federal consultation practices are, just in part because one of the things that I've seen is commonality between state tribal consultation practices is how they very much are built on federal consultation practices. I'll give some examples of, again, what else might be happening in California and in Minnesota, because there's some other areas where there's some of this relationship. And then I'll end with some things to think about. What are the major benefits and other considerations for why states should be looking more at formal government to government relationships with formal tribal consultation practices. Okay, next slide, please. So just a quick background. I don't know how many of the attendees on the webinar have attended previous webinars. If so, some of this may seem familiar. If not, just the understanding that tribes are governments, right? They're not minority communities. They're not stakeholders in state governmental processes. They are not political interest groups. They are governments, and they are pre-existing governments, right? Tribes were in the U.S. before the colonists showed up and before everyone else showed up, and certainly before the United States itself became a country. So tribes have, because of that, inherent and pre-existing sovereign rights and authorities. The Supreme Court has eroded some of those inherent sovereign rights and authorities. The federal government, as the superior government, certainly the superior jurisdiction, has eroded some of those. And the Supreme Court has explained that in many Supreme Court decisions that tribal sovereign rights and authorities are inherent, they're pre-existing, and the tribes have the same sovereign rights and authorities that they've always had, except and unless they give up those rights or the federal government takes those rights, because it can, or by reason of their status, as the John Marshall Court said back in the 1830s, their domestic dependent nation status. But leaving kind of those diminished authorities aside, tribes are also extra constitutional. Why? We're not part of the constitutional convention. We're certainly not part of the constitutional scheme. It's the federal government and it's state governments. It's not tribal governments. We are mentioned, of course, in the Constitution in Article 1, Section 8, which is the Commerce Clause, where Congress has the full and sole authority to regulate commerce between the states and with the Indian tribes. Unfortunately, the federal Supreme Court has expanded what they think that Commerce Clause means to include things like plenary power, that the federal government and certainly Congress has plenary power, that is absolute power over the tribes. Lots of discussion even now happening at the Supreme Court about whether that is a flawed Supreme Court doctrine. That's a made-up Supreme Court doctrine of plenary power. But leaving that aside, the Constitution itself mentions tribes once, mentions Indians in a couple of different ways, individual Indians, but not with respect to the governmental status of tribes. So the governmental status of tribes have really been solidified through acts of Congress and through decisions of the Supreme Court. And that status has also been recognized through treaties with tribes. Over 300 treaties were entered into with just between the United States and tribes. Great Britain entered into 200 treaties or more before the United States became a country. After that, then the United States itself entered into over 300 treaties with tribes under the treaty clause, which is in Article 2, which is the president, right? The president has the authority to make treaties. They have to be ratified by the Senate, confirmed by the Senate. So over 300 treaties, that ended in 1871. But that really forms the government to government basis, right? A nation makes a treaty with another nation. So it's important to recognize that also is the legal foundation between the government to government, nation to nation, as some folks might say, relationship. And again, the U.S. Constitution recognizes Congress's authority to regulate commerce with the tribes. And then lastly, again, because of the Supreme Court's kind of characterizing tribes in the context of this constitutional order as domestic dependent nations, that denotes a political status, not a racial status, not a minority status. We, of course, are racial groups and have minority status because there's about 2% of the population, I think was the last census number. 2% of the U.S. population has some Native American ancestry. But as tribal members, people enrolled in tribes, tribal citizens, we have a political status. The Supreme Court in the 1970s, mid-1970s, clarified that under a case called Mancari v. Morton, where the Supreme Court clarified that tribes and tribal citizens have political status, not racial or minority status, and therefore Congress could pass laws that benefit tribes, that are specific to tribes, and that don't violate due process and equal protection under the 5th or 14th Amendments of the U.S. Constitution, but instead, as a political status, Congress, as long as it's a reasonable rule and regulation. And so we have in the federal laws, at least, one whole title of the U.S. Code, Title 25, Indians. And it's all the federal Indian laws. So it's important to recognize that the federal government, at least, Congress, the courts, and of course the president, the executive branch, of all recognized tribes as political entities with which it has a government to government, nation to nation status. Next slide, please. Just a quick background. I call it the modern history of government to government because if you're familiar at all with Indian policy, it's up and down, back and forth, forwards and backwards. But since 1970, when President Nixon issued his special message to Congress on Indian affairs, that's when really the modern self-determination era, as we call it, began. And at the time, the Congress was involved in what they called termination again. So President Nixon, who was a great friend to Indians, issued this special message calling for a rejection of termination policies and a promotion of self-determination. Shortly thereafter, the Indian Education and Self-Determination Act from 1975, that was actually legislation that was drafted by the Nixon administration. As we know, President Nixon resigned in 1974. So President Ford carried forward on that law. And it allows tribes, and it's still very much in use today, but it basically recognized that tribes had the ability to not only self-govern, but also self-determine. And by that, we mean making decisions for themselves about their citizens, their governmental structures, their governmental support and services to their citizens. Up until then, the federal government had statutory or treaty responsibilities to provide services for tribes and tribal members: courts, law enforcement, social services, real estate services, general tribal government support. And under the ISDA, as we call it, Congress said, well, we'll let the tribes decide for themselves. Tribes can contract with the federal government. We will pay the tribes the money that would otherwise be spent by the Bureau of Indian Affairs or Indian Health Services. And instead, we'll give that money to the tribes to perform those services themselves. So virtually every tribe has a Self-Determination Act contract. We call them 638 contracts because that's the public law. And a handful of tribes don't, mostly because of size or capacity. And so that also built up both the federal government's relationship with tribes. Tribes are now performing these federal services, performing their own law enforcement, performing their own health care, running their own court system, supporting their own governments through federal funding. And that it was important because it helped to build tribal capacity and especially tribal governmental capacity. President Reagan in 1984 issues his EPA tribal policy. This is the first known formal acknowledgement that the federal government wanted tribes to take over kind of non-638 programs. So the emphasis of the President Reagan's tribal policy was that tribes should be responsible for managing their own environmental programs on tribal lands. So again, not 638 contracting, that's limited to social services, etc. Now it's non-BIA programs. Now, admittedly, this was part of President Reagan's effort to push all environmental programs out to local government and state and local governments. And but the key here was that he included tribes. They included tribes. They have 9 principles behind this policy. This policy is, like the ISDA, very well active and ongoing. The EPA reverts to this policy almost regardless of administration. Even the current administration has been very forceful in working with tribes to manage their own environmental programs. Now, they're not very good with the money, but they are still in this effort of just pushing as much stuff out into Indian country, especially around the administration and operation of environmental programs. The first formal government-to-government consultation policy occurred under President Clinton. I have this 2000 policy listed here, Executive Order 13175. But there was one issued earlier in 1994, and then 2000 was the last one. And that's the most recent one. It hasn't been updated, hasn't been amended, hasn't been revoked, thankfully, by this president yet. But this is kind of the gold standard for consultation. And what it really did was solidify the federal government's consultation policies and practices across federal agencies. So as you heard from Minnesota, they've codified their tribal consultation practices in law. We don't have one in law under federal law. Almost all our consultation practices are either regulatory. So, for example, under the National Historic Preservation Act, there are regulatory processes for tribal consultation, or their executive order or agency order. But they're as close to codified as you can get, but certainly having it written down, having a uniform process and ensuring that every agency in the federal government was conducting tribal consultation under specific purposes. With respect to state tribal relationships over this same course of time, it's checkered. Admittedly, there are some states that have great relationships with their tribes. You've heard from two of them. There are lots of others like that. There are some states that have horrible relationships with their tribes. I won't name them. Maybe some of you are in them, but it's important to note that it's not consistent across the 30 plus states that have federally recognized tribes within their territories, within their boundaries. Other states have been very consistent on this. Some have gone back and forth depending on the governor in the governor's mansion. So hopefully the states and the folks that are on this call are interested in building up your tribal consultation practices, solidifying them, maybe even just starting them. And so hopefully this will give you guys some good information on how to proceed with that. Okay, next slide, please. So just quickly, just some of the different types of tribal state relationships that we've seen that could also be a model for working in the energy space. So as you've heard, 30 plus states with federally recognized tribes. Of course, 30 states means 30 different sets of challenges. Each state's different for a reason. Each set of tribes in each state is different. Some tribes cross multiple states. Some tribes are affiliated with other tribes in other states. Many tribes, especially those, for example, in Oklahoma, Kansas, even Texas, mostly parts of the Midwest, that part of the Midwest, have all been removed from their Aboriginal territories. So the best example, the 5 civilized tribes of Oklahoma, Cherokees, Creeks, Choctaws, Chickasaws, and Seminoles, none of them are from Oklahoma. They're all from Georgia, Florida, Louisiana, Mississippi, Tennessee, parts of North Carolina, and yet as part of the removal era are now in Oklahoma. Many other tribes from the Ohio River Valley, the Shawnee, the Pawnee are all down in Oklahoma now. So those types of challenges also exist as between the states and the tribes, in part because of the history of federal Indian policy. Some early adopters from tribal consultation, New Mexico, I think again is the first state that I've seen in my research that was the first one to have a formal tribal consultation policy, and I'll talk about theirs in more detail in just a minute. But we also see lots of cooperative relationships as between tribes and states, or tribes and state systems, state agencies, that again could serve as a model for improving a relationship around energy. So child welfare is one. We have the Indian Child Welfare Act that requires state courts to have a different set of standards when they're dealing with children from Indian tribes, and tribes, either tribal court systems have worked out very good working relationships with state court systems, or the states themselves have adopted ICWA-like standards under state law, with more cooperative relationship between child welfare agencies of tribes and states. We see a lot around taxation now, where the Supreme Court has held states can tax non-Indians on Indian lands. Of course, tribes can tax people on Indian lands. So states and tribes have worked through taxation compacts to be able to efficiently and reasonably and fairly share tax revenue. Gaming, of course, is the biggest one, where under federal Indian law, the Indian Gaming Regulatory Act, Congress has required tribes to enter into gaming compacts with states with respect to Class 3 gaming. That's the Vegas style gaming. So where you have big casinos, those tribes have negotiated agreements with the states. They share jurisdiction. They allocate jurisdiction. They sometimes allocate regulatory functions. Some states are pretty hands-off from a regulatory perspective with Indian gaming. Other states are very hands-on. So that's all been negotiated between the tribes and the states. And then lastly, law enforcement, where, everybody, public safety knows no bounds, right? It's a lot like dirty air. You just want to make sure that you've got it all covered across different jurisdictions. And so lots of tribes have entered into either mutual aid agreements or cross-deputization agreements or what have you with respect to law enforcement, and divvy up that jurisdiction and ensure there's no gaps, if you will, in jurisdiction and public safety enforcement. Okay, next slide. So let me turn to some of the feds and what they do. So the fundamental principles under the federal consultation practice: protect and promote tribal sovereignty, self-determination, and self-governance. A lot of big questions that people have about tribal consultation is, when should I consult? How should I consult? Who do I consult with? How often? And what do I do with it when I'm done? So the federal government has the executive order is very high level. It at least identifies what the trigger is. So agencies are required to consult when they're going to take action. And the next portion of that is what does that mean? Regulations, legislative comments or proposed legislation, other policy statements or actions that have a substantial direct effect on one or more tribes. So policies, in short, policies, regulations, guidance, actions that have tribal implications. One of the other aspects of the federal policy is the acknowledgement of tribal self-determination and self-governance, that even if the feds are going to put out a policy that requires, the general public to do X, right, a regulation, that they're still supposed to give consideration to tribes, administrative flexibility to tribes. So tribes should have more power to design how they're going to implement those things versus how, another entity subject to the rules might have to implement it. And then each agency should implement specific consultation procedures. The executive order encourages independent agencies to follow them. This was back when the president didn't think he had jurisdiction over independent agencies. So EPA, independent agency. FERC, independent agency. They both have, they're not subject to this executive order, but they follow it. Okay, next slide. So what have we seen with some of the other states? So New Mexico, as I said, was one of the first ones. Governor Bill Richardson, who used to be the secretary of the Department of Energy, he was a congressman, became secretary of DOE, went back to New Mexico and became governor. He issued a statement in 2003 on policy and processes, was signed jointly by the governor and the pueblos and tribes of New Mexico. 2005, he issued a formal executive order around adopting tribal consultation plans and directing agencies to do that. And then in 2009, the state enacted the State Tribal Collaboration Act. So in that law are the requirements for each state government agency to have a tribal consultation plan. And to my knowledge, this is the first law passed by a state that requires tribal consultation. It also elevated what was then the Office of Tribal Affairs to become a cabinet level department. Again, the first state to elevate their Office of Tribal Affairs. Lots of states or governors have tribal advisors. Maybe they have commission on Indian affairs, but New Mexico was the first state to elevate it to a cabinet level. Next slide. So in this Collaboration Act, which Minnesota has a similar law as this Collaboration Act, but again, this was the first one. So it requires every state agency to develop and implement a policy that, like the federal policy, and again, a lot of consistent elements across these tribal consultation policies. Promotes effective communication, promotes a positive government-to-government relationship, promotes cultural competency. You heard about the tribal advisors in Minnesota and California. We have a responsibility to train everybody Under the state of New Mexico, every employee that does any interaction with tribes has to have cultural competency training. There should be a method for notifying employees of the provisions of this act. And then the state agency in New Mexico has to make a reasonable effort to collaborate with tribes. They have to have a tribal liaison. They have to have an annual summit with the pueblos and tribes. And there was required training and an annual report to the Department of Indian Affairs. So every state agency has to do basically what you heard Minnesota PUC do. This annual meeting with tribes, outreach, and a report for accountability. Next slide. So quick example of what in New Mexico, the Energy and Minerals Department, their PRC has not issued a tribal consultation policy, but the closest thing to them is the Energy and Minerals Department. So here's a link to their policy at New Mexico. And again, the same principles reflected in this policy: recognize and respect tribal sovereignty, promote government to government. There is a recognition of having informal communications and protecting confidentiality. This is, I know, a huge issue that a lot of state and federal government agencies have is if I'm doing consultation with tribes, say around a big energy project that's being located somewhere, and part of that consultation involves protecting important cultural resources or sacred sites, or could have an impact on tribal treaty rights in Minnesota, for example, right? There's lots of off-reservation treaty rights. A lot of tribes still have off-reservation interests. So tribes will be more than happy to talk with state agencies about this is going to have an impact on this, this, and this. But they also want to make sure that those important cultural resources, that important cultural information is not shared, that it's protected by confidentiality. Under federal law, the National Historic Preservation Act, important tribal cultural resources, sacred sites have to be protected. There's a statutory requirement for confidentiality. Not necessarily under state law, but for the agencies like New Mexico's Energy and Minerals Department, where they have said, we will protect the confidentiality of the consultation and this information, that can be an important element to tribal consultation practices. Their comment here about, their principle here about utilize informal communication reminds me of this thing we used to say at the federal government, how we would have big C consultation and little c consultation. Big C consultation being formal. We call a consultation meeting. We might put out a list of questions beforehand that an agency wants the tribes to review and be prepared to answer. There might be a series of consultation meetings or Zoom calls. There'd be a formal written comment period for that consultation where the agency would take in formal written comments. And so we call that the big C. You usually see that when there's maybe a proposed rule or a big national guidance or something specific to tribes. And the agency wants to, one, show that they conducted tribal consultation. They might have a requirement in their rulemaking to conduct consultation. So they have to show that in the preamble that they conducted consultation and the kind of comments they received. And then other agencies would, maybe if it's not a formal rule, but a guidance or some other changes they're making that they know is going to impact tribes, they would have formal consultation. The informal communication is identified here as more like little c. It's the day-to-day conversation with the tribes. It's the pick up the phone and call, the staff person at the tribe's utility authority or the tribe's natural resources department and say, hey, we got some stuff coming up. Can we come in and talk to you guys about it? Or especially where there may be some operational issues or operational activity happening. That's not going to rise to a big C. It's not maybe statewide. Maybe it's specific to a tribe. Maybe it's specific to an action. So informal communication can be just as critical as formal communication. And the fact that New Mexico has got this in there shows that they understand the multi-layers, multi-levels of communication and consultation that occur with Indian tribes. So I encourage you to take a look at their policy. And again, that's the link. Okay, next slide. So I had, if you are interested, my broader presentation has a little bit more detail on some of the things also happening in California. California Energy Commission, which is a sister agency to the CPUC. They regulate other aspects of energy. They also have a tribal consultation policy. They actually are undergoing a formal proceeding now with tribes around tribal energy sovereignty. My other presentation, I don't know, Allison, if we're going to have a link to some of those documents that we had. I think they're up on your website. But I would encourage you to take a look at what the California Energy Commission is doing. And then in Minnesota, I did not hear whether the commissioner mentioned the Tribal Energy Advisory Council that was established, well, formally created by statute again, but it's housed in the Minnesota Commerce Department, not in the CPUC. The Commerce Department is kind of the keeper of Minnesota's energy policy writ large, also does a lot of grant programs. And they stood up a formal tribal energy council made up of all the tribes in Minnesota. And they get regular feedback from the tribes directly around energy development opportunities, again, energy sovereignty. So those are just a couple of other things that are happening in California and in Minnesota that may serve as a model for other states. All right, let me end with just this comment about major benefits and considerations. So many states, as I said, already have existing relationships with tribes and other areas, building on those to cover energy, energy development, energy regulations, energy opportunities. As we know we've got data centers coming in. We've got a shift in the federal energy policy, but many states are keeping with their own clean energy policies. So it's a good way to model how states have worked with tribes in other areas and bring that model here. We can model those other co-regulatory mechanisms that we see. I mentioned law enforcement. I mentioned gaming. Another area that's coming up is healthcare, where tribes are taking on more and more of their healthcare through federal support, hiring their own doctors and their own nurses and running their own hospitals. And that too is a very highly regulated, running their own pharmacies. So there's some other co-regulatory mechanisms that are coming up. Promotes cooperation and coordination with tribes rather than conflict and confusion. And that's especially critical for energy developers and utilities. Tribes want to assert their own sovereign right to regulate utilities serving their reservations. They can, and they have the legal authority to do it. Now, if a state's already regulating the utility is going to go, who do I follow, the state or the tribe? The answer is yes. So there's opportunity there for states and tribes to work together, especially in the regulatory space where there's co-jurisdiction on cooperation and coordination rather than creating conflict, confusion, and avoiding, of course, lawsuits. And then lastly, there's huge engagement opportunities around training, cultural awareness, relationship building, and help tribes working with and for states around state energy policy goals and vice versa. Tribes have their own energy policy goals, and states could be a player and a coordinating and cooperative co-government with tribes achieving that. So with that, I know we've only got a couple of minutes left. Allison, happy to take any questions.
Great. Thank you so much, Pilar. That was wonderful. And we will make sure and post all of the full slide deck, which is also posted under our workshop materials, but we will post that as well. We do have one question. One of our attendees asked if there are any suggested best practices for engaging unrecognized or traditional indigenous governments who may be outside of the elected tribal council system. Pilar, do you want to start?
Yeah, let me maybe clarify. Is that like a state recognized or unrecognized tribe, or is that like a civil organization of tribal members? Two different things. So let me just I'll answer my question both ways.
Okay.
With respect to state recognized tribe, California has a handful of state recognized tribes. Other states have state recognized tribes. In that case, the state is free to have whatever government to government relationship with them. Tribal governments don't have to be federally recognized to be a tribal government. There are a handful of court cases where state recognized tribes, the courts have acknowledged they have the same sovereign rights and authorities as federally recognized tribes. The only difference is federally recognized tribes get access to federal benefits and services, and the federal government only deals with them except in a handful of cases. So I don't think there's any real difference between those two, unrecognized or state recognized. Now, if it's like a organization like Dene Cares, which is a nonprofit made up of Navajo members who are just like any other NGO, civil institution, not a government. So it is important to recognize the difference between like a nonprofit that might be speaking on behalf of tribal members versus a tribal government that may or may not be federally recognized.
Great. Thank you, Pilar. We are at time, but I do want to share just one more thing if I can. Just want to remind everyone that we do have a project website where all of our deliverables are available, including recordings of our previous webinars, which took place earlier this year. All of the materials from both of our workshops are posted, as well as the 6 fact sheets that we developed for the Office of Policy. So please do check that out. And Pilar, you'll be excited to know there's actually one more webinar taking place on Introduction to Tribal Sovereignty and Governance. It's going to be featuring Margie Schaff. That'll be March 18th from 2 to 3 Mountain or 4 to 5 Eastern. And you can find that registration link on our website as well. So I want to thank all of our presenters. We're so grateful for your expertise, for taking the time out of what I know are very busy schedules to be able to share your experiences with us. So thank you again, and look for the recording to be posted on our website. And please share with your colleagues. Thank you all so much.
Great. Thank you, everybody.
Thank you.
you.